Allen & Company wishes OOIDA and all members a safe, healthy, and joyous holiday season.
OOIDA, representing America's truckers since 1973, presents Landline Now with your host, Mark Reddick.
We're closing out 2024 by taking a look back at the stories that made the biggest impression over the past 12 months. Today, we'll look at nuclear verdicts against the trucking industry with Tyson Fisher of Landline Magazine. FMCSA for years toyed with the concept of requiring speed limiters in most trucks. I'll discuss that, plus potential upcoming action on broker transparency with OOIDA Director of Federal Affairs, Jay Grimes. A trucker recently encountered a situation that involved a broker, shipper, and receiver, as well as detention time and coercion. Tom Crowley and Aaron Lynch of OOIDA's Compliance Department tell us what happened and what consequences the trucker faced. And finally, over the holiday, a federal appeals court made a decision that will reinstate the requirement that small businesses report beneficial ownership information. I'll find out what that means to you from Landline Magazine's Jamie Jones. And now, here's Scott Thompson.
Thanks, Mark. We're closing out 2024 by taking a look back at the stories that made the biggest impressions over the past 12 months. We're talking broker fraud, speed limiters, and more. But today, we're going to look at nuclear verdicts against the trucking industry. There's been a few big headlines this year. And joining us to discuss is Tyson Fisher, Associate Editor of Landline Magazine. Tyson, how you doing?
Fantastic. What a year, right?
It has been a year. That is a fact. Fact check true. Yeah, it's certainly been a year full of a lot of things going on. Nuclear verdicts. This has been a big one, and we'll talk about the implications of all these nuclear verdicts here in just a moment. But I first think that we should recap what we saw this year. There were, I think I can count at least three big nuclear verdicts against trucking companies.
There were three that
really big ones, right?
Really big ones. So try to burn through these real quick. So in Texas, Warner got slammed with a $100 million verdict. So a passenger vehicle crossed the median into oncoming traffic, struck a truck that was driving 100% legal. In Missouri, Wabash, this is the big one, nearly $500 million with a B, so it's like $460 million. Passenger vehicle drove into the back of a nearly stopped truck, killing both occupants of the passenger vehicle. The jury found Wabash liable due to unsafe rear underride guard, despite the fact that the underride guard met all federally required specifications. The trial attorney alleged an industry-wide conspiracy to restrict regulations dating back to the 1960s. Wabash was founded in 1985 or something like
exactly.
that. And then Daimler Truck, $160 million in Alabama, very similar to Wabash. A trucker sued the manufacturer after a truck rollover that left him paralyzed. He claimed that the roof and driver's seat designs were defective and unreasonably dangerous. Again, met all federally required specifications. So a trio of major or high nuclear verdicts where it just defies all logic and reasoning when you look at the facts of the case.
Yeah, that's the thing. I mean, the initial headline makes your eyes pop a little bit because of just the sheer amount of money that they're awarding to these people. But then you look at the facts of the case, as you mentioned there, and the questions of who was at fault. When you take those two things into account here with, again, higher amounts and a higher number of these nuclear verdicts, it just doesn't seem sustainable, which is where this talk of tort reform has been coming in. And we've really seen a lot more talk, I think, this past year about that need, right?
So as far as it not being sustainable, look, these nuclear verdicts make up like a fraction of 1% of all crashes, but the trickle-down effect of the nuclear verdicts that it has on the trucking industry, I mean, that's significant and far-reaching. So a large verdict can put a company out of business, but like all of these large verdicts, a trend of costlier, more frequent litigation leads to higher insurance premiums. And so, there's a call for tort reform as you mentioned, and that can look like many things. So like one thing is this thing called reptile theory. That's when the plaintiff's attorneys kind of paint the corporation or the company as this big evil corporation that's out to kill people and all for the sake of profit or whatever. No, it's kind of, again, to tap into that reptilian part of the juror's brain that evokes anger and fear and all that. There are ways by which tort reform can reduce the use of reptile theory, at least tamper it down a little bit to where it's a little bit more reasonable. It's difficult to do, but a thing that's more manageable is caps on damages. We're seeing that kind of tort reform across several states. There's no caps in Missouri, for example, and so that's something that can be addressed. The Wisconsin governor recently vetoed a bill that would have capped it. So there are efforts. Sometimes those efforts go through, sometimes they don't. But I think caps on damages and seatbelt use as evidence are two big parts of tort reform that the industry can work on. Because when it comes to seatbelt use, that's not always admissible as evidence, even though it could be a significant factor in whether or not a crash could have been fatal or not fatal.
Right, yeah. And, we see these attorneys sort of licking their chops now because we see these big numbers come out, and as a result, you're going to see more lawyers going after big companies because they see the payday there. You mentioned the fact that states are looking at this now. There are a number of so-called judicial hellholes across the U.S. It seems like states are taking notice and trying to do something about this, but this is going to be a slow slog, right?
It is, because the thing about tort reform is that is state by state. States have control of their tort law, so it's not like we can go in and have like a federal law to where all states have to admit, seatbelt use as evidence. So you have to go state by state, jurisdiction by jurisdiction. Yeah. It's a lot of work, and so that's kind of why it's difficult to get the results we want. But you mentioned judicial hellholes. These are places where it's the worst when it comes to tort laws, and Georgia's on the top of the list, but you got Chicago, California, New York City, St. Louis, which is where Wabash got deemed. St. Louis also handed down a $500 million verdict against a baby formula manufacturer earlier in the year as well. Yeah. And so that's a problem, and so it's not coincidental that, two $500 million verdicts were handed down in St. Louis County. And so you got to kind of find where these places are and kind of address it that way, just kind of a piecemeal effort.
Yeah, it is still worth mentioning that nuclear verdicts are rare. As an owner-operator out there, you may not be as susceptible to these types of things, but make no mistake about it, this is something that could devastate anybody out there. Real quick, ways to protect oneself to make sure that this doesn't happen?
Yeah, I mean, it just is as simple as be safe and compliant. Just cross your T's, dot all of your I's when it comes to compliance, safety regulations. Just do everything by the books, as most drivers do.
Absolutely.
Just keep doing what you're doing. Don't worry about, getting sued. Just if you just do what you're supposed to do, you should be fine. But, and sometimes you can go the extra mile. There's some safety technology that's not invasive that you can put onto your truck that that pleases the insurance company. So again, just keep doing what you're doing and do it safely.
This is not the last we've heard about nuclear verdicts, sadly. I'm sure we'll talk about it in 2025 moving forward. And Tyson, we'll talk to you again here in the coming days about more top stories from 2024. We appreciate it.
Look forward to it. Thank you.
That was Tyson Fisher of Landline Magazine. Mark, back to you.
Thanks, Scott. Are you one of the many truckers who's had a broker spring endless fees when you did your job and got the load delivered? One way you can combat that is by making those transactions transparent. And now FMCSA is proposing a rule to do just that. It's easy to do your part and make your views known. You can file comments or find a guide about how to do that at fightingfortruckers.com. Next, I'll discuss speed limiters and broker transparency with OOIDA's Jay Grimes, and we'll hear about some common problems truckers encounter from Tom Crowley and Aaron Lynch. We'll be right back. I'm Mark Reddick, and this is Landline Now.
Thanks for listening. Be sure to like and subscribe. If you want more content, go to landline.media to get updated news, information, and archived editions of our show. Once again, that's landline.media.
Penske owns and operates some of the best-maintained vehicles on the planet. Our used trucks come with a 5-year maintenance report and pre-sale inspection. So if you're in the market for a top-quality pre-owned truck, look no further. Search our inventory today at PenskeUsedTrucks.com.
Capital Reman, the leader in remanufactured diesel engines and components, has partnered with OOIDA to offer exclusive member benefits. Visit CapitalReman.com today to support America's transportation industry and take advantage of your benefits.
It's tested and proven. Burn 2.1% less fuel when you balance all wheel ends with Centromatic. Call 800-523-8473 to get the OOIDA discount.
The Federal Motor Carrier Safety Administration has for years toyed with the concept of requiring speed limiters in most trucks. But due to a number of factors, including heavy pushback from truckers and OOIDA, that hasn't happened yet. Welcome back to Landline Now. This is Regulatory Roundup, and I'm Mark Reddig. I'm joined, as always, by OOIDA Director of Federal Affairs, Jay Grimes. Jay, how are you doing?
Doing well, Mark. Happy holidays.
Well, to you as well. Absolutely. This is a hot button, to say the least. And I'm wondering if we can start with just a little bit of history here, because as I said, this is a long-running issue in the trucking industry. Can you give us an idea of what's happened in the past few years that's led up to this point where we are now on speed limiters?
Well, we could go back quite a bit. I'll kind of do a quick rundown. 2016, FMCSA and NHTSA put out a joint notice of proposed rulemaking, kind of the first time a formal rulemaking to require speed limiters, I think due to a lot of opposition. That rulemaking did not advance and kind of went away for a few years. And then kind of unexpectedly, April 2022, FMCSA put out a supplemental notice of proposed rulemaking, sort of reopening that rulemaking process. And this was an FMCSA effort this time around, looking at some of aspects of the electronic control module in text, but it really had the effect of kind of opening up the whole ball of wax. There again was another public comment period where over 15,000 comments were submitted to FMCSA. I think the overwhelming majority were in opposition. Certainly, that's always been our position here at OOIDA, given the safety concerns, the practical concerns, the operational problems, taking away control of the vehicle from the driver, among a whole host of other issues there. And we were really, I think, fearful that FMCSA was going to be pushing forward no matter the opposition they heard. But as we have seen since that supplemental proposed rulemaking came about, FMCSA has delayed putting out the next step in the rulemaking process. And as we are here at the end of 2024, they have delayed that quite a bit. And formally and officially, the next phase of the rulemaking is now projected to come out in May 2025. Kind of looking at things, given the fact we're going to have a new administration taking over here January 20th of next year, new Congress coming in here in the next couple weeks with a slim Republican control in both the House and the Senate. I think we're cautiously optimistic that advancing a speed limiter mandate is not going to be a top priority here for the foreseeable future. Of course, nothing is settled on that, so we're going to be continuing to push back against any efforts that would mandate a speed limiter rulemaking, mandate a certain speed. But kind of looking back now, I think, done a great job in mobilizing opposition, going to continue to do that, hoping that we're not going to have to continue to do that here over the next couple of years, but you never know, and we're going to continue to make our case until there is official action that the rulemaking is withdrawn or legislation is enacted that would prohibit FMCSA from advancing any speed limiter mandate.
You mentioned legislation. There actually is a bill on Capitol Hill right now that would shut this process down, isn't there?
Yeah, the DRIVE Act has been introduced this Congress, and we're going to make some efforts to reintroduce it here as the new Congress begins. And this was legislation that now has over 50 total co-sponsors on both the House and Senate side, including Vice President-elect J.D. Vance. And I think it really showed that, it's kind of a reminder here that this speed limiter proposal from FMCSA has never been a congressional mandate. This is the agency kind of acting on their own fruition based on some petitions from large carriers, from safety advocates over the years. I think we've got some questions on how practical it would be for safety and the effects it would have on small businesses. I think the 50 members of Congress who have co-sponsored the DRIVE Act understood that message. So as the new Congress gets underway, it's certainly going to continue to educate lawmakers to push forward with the DRIVE Act. Hopefully it's not as necessary under the new leadership at DOT, but I think it's going to be always good to have in our back pocket to have that legislative support that would prohibit FMCSA from moving forward in the future.
I do want to get a little bit more into the weeds here, and I may be going too far. Those weeds are getting tall, but there was always before a principle put out by the courts called the Chevron doctrine, that basically the courts would defer to the expertise of federal agencies in making some of these rules. That was overturned earlier with a decision called the Dobbs decision, which basically put that power, for the most part, back with Congress. And you mentioned that Congress never called for this. Is this something where that court decision could have an impact on whether or not this would ever get through?
There's certainly a potential here, pending any unforeseen legislative action that would compel the agency to move forward with the speed limiter rulemaking. But as it stands right now, yes, kind of given that Chevron ruling, any rulemaking now kind of moving forward that doesn't have specific congressional intent is going to be under a little bit more scrutiny if they are challenged legally in the court system. So if this speed limiter rule is eventually finalized, and hopefully it never gets that far, I think this one could be a prime candidate for legal challenge, kind of considering some of the recent federal court rulings that we have seen when it comes to the power of executive agencies.
Okay. Well, let's move on to another topic here. This is an issue that we have discussed recently here on the program, and that has been a long-running issue in the trucking industry, and that's broker transparency. And now there may finally be movement on fixing some of the problems with that issue. But I do, as I always seem to, want to go back a little bit, Jay. There's been a regulation on the books for decades calling for this. What is that current regulation?
Yeah, regulations under 371.3, specifically 371.3 subsection C, that requires really regulates that motor carriers have a right to review transactional information when they request it from brokers. Unfortunately, motor carriers are often denied that right. There's all sorts of different tactics and loopholes that brokers kind of use to their advantage to prevent motor carriers from ever actually viewing those records. And then certainly we know that it's not been a priority for FMCSA to really enforce those regulations on the broker side of things. So it really creates a kind of an unfair balance between motor carriers and brokers when it comes to transparency, transactional information, negotiation of rates. And we petitioned FMCSA to improve broker transparency back in spring of 2020. There were a host of various public comment periods that were opened up, different listening sessions where FMCSA, I think, really heard what the industry thinks about the need to improve broker transparency. And finally, after over 4 years, just about a month ago in November, FMCSA published a notice of proposed rulemaking to improve broker transparency and put out 4 key provisions, really requiring the electronic transactions within a 48-hour period, requiring that brokers maintain their records electronically, and amending some of the regulatory language to ensure that brokers have an obligation to provide this information. I think the 4 key provisions are helpful, a necessary first step. They don't accomplish all the stuff that we wanted to see in our petition, but I think lay the groundwork and have opened up another public comment period here that's open through January 21st, 2025, not only to maybe see what's good in this proposal, but also hear about ways it could be improved. Another main concern that really isn't addressed in the proposal is this practice of brokers putting in waivers in contracts where carriers have to waive their rights to view transaction records if they want to haul a load. And that's something that we think needs to be addressed in a potential final rule. So certainly a lot to comment in, and it's really important to make our voices heard here as the new administration comes in later here in January, as the new Congress begins here at the end of next week, to make sure that broker transparency remains a top priority for FMCSA and for Congress here over the next couple of years.
You mentioned the contract clauses that brokers frequently put in that basically where carriers, by signing the contract, are waiving their rights to review that. But I know another big way that some brokers are getting around this is they basically say, okay, we'll give it to you. You have to come to our physical office in person to get this information, which, if you're in California and their office is in New Hampshire, is not really doing you a lot of good. It does appear that this proposal would address that problem.
Yeah, and the agency specifically points out that brokers kind of use that example, kind of illustrating the inequity between the current system and how this proposal could be beneficial. And yes, requiring records in an electronic format will make it easier for motor carriers to review records on request. And FMCSA says that this will eliminate the loophole that brokers use to conceal information by making only those physical records available at their principal place of business. So that electronic records requirement speaks directly to that problem of being forced to view the physical records at the principal place of business. If that provision is maintained and upheld, that practice would be eliminated.
We've talked about the fact that FMCSA is taking comments on this proposal right now. And, of course, folks, if you do want to make those comments, you just have to go to the website, fightingfortruckers.com. There's a link there about broker transparency. You can get in there. It has all kinds of information, and it has a place where you can go ahead and put in your comments, and it'll send it to FMCSA. But Jay, here in the minute that we have left, are there some things specifically truckers should be sharing when they make these comments?
Yeah, encourage everyone to visit fightingfortruckers.com. We've got a helpful comment guide that provides a little more information about how each of the provisions might work, but also some of the ways that the rulemaking needs to be improved if it really wants to have the substantive effect that we need it to have. But also, just generally, would broker transparency help your business? Do you think it's fair that brokers can willingly evade these transparency regulations without enforcement? What impact do you think these changes would have on freight rates? And kind of a big one, have you been blacklisted by brokers for requesting transaction information? And would this proposal encourage or discourage those types of practices? So Fighting for Truckers has all the info that can help you fill out these comments here before January 21st.
Okay. Well, Jay, thank you very much for the information.
All righty. Thank you.
I've been talking with OOIDA's Jay Grimes. Landline Now will be back in a moment.
Running on ultra-low sulfur diesel? Stay protected this winter with Howe's Diesel Treat and Diesel Lifeline. Steer clear of gel and ice with North America's #1 trusted brand. Find Howe's products nationwide at select retailers, auto parts stores, truck stops, and on Amazon.com.
When it's time to overhaul your truck engine, help protect it by insisting on a genuine Vibratech TVD crankshaft damper. Heavy duty, absolute premium quality, and they're made right here in the USA. Find a dealer at VibratechTVD.com.
Truckdown.com. Whenever you have a breakdown, you need Truckdown.com. 24/7 access to 40,000 verified heavy-duty repair vendors nationwide.
Vendor choice. Owner-operators rejoice.
Truckdown.com.
Landline Now. Welcome back. We talk a lot about common issues that truckers face out on the road here on the show, but we generally talk about the issues without talking about specific truckers who have faced those situations. But every once in a while, we hear from a trucker whose story is worth sharing and that demonstrates why these issues are important for you to understand and know about. Here to discuss one case is Tom Crowley and Aaron Lynch of OOIDA's Compliance Department. Guys, thanks for joining me.
Glad to be here, Mark.
Thanks as always, Mark. Good to be here.
Let's start out, Tom. Just tell us this story. What happened to this guy?
All right. I got a call here a couple weeks ago from a fella that he had went to the shipper. This was just an overnight delivery. Supposed to pick up on a Thursday, deliver on a Friday. It put him right close to home where he wanted to be. You know, it was supposed to work out real well for him. Last minute thing. So he took the load and got to the shipper and was supposed to get loaded that morning, and had the rest of the day to get to the receiver. Well, got to the shipper, and he didn't get loaded that morning. He sat all day long. I mean, he sat for about 9 hours before they finally got him loaded just before the end of the day. Well, his clock had started that morning, and he had, so burned up a lot of his clock. So he called the broker as he left the shipper saying, "Hey, I'm just now getting out of here," which he had been in contact with him and told him several times, "I'm still here, I'm still here, I'm still here." "Oh, yeah, don't worry, we'll take care of you on that," as they say. So 5:30 that afternoon, he finally got out, and he said, "Hey, hours-wise, I do not have the hours to legally make this run and make that delivery in the morning." "Well, don't worry about it," the broker told him. "Don't worry about it, we'll take care of you. Just go ahead and get on over there and do the best you can." And meaning try to make that delivery. Well, there was no way that he was going to make that delivery, not legally. So he did get over there the next morning, and it was a little later than the delivery time. He got there, went to check in, and they told him, "Oh, well, yeah, you missed your appointment. We'll have to reschedule you." So they pulled this reschedule thing. Well, then the broker said, "Yeah, we rescheduled you for Monday." And the guy was pissed. I mean, he said, "What? Now, wait a minute. I told you I was late. I told you I was late getting out of there." And he said, "Well, at least what are we going to do for layover stuff?" The broker would give him no layover confirmation, no new rate con, no anything. I mean, and I talked to this guy several times on Friday, and he was upset. He was like, "What are my options?" He was really, really mad.
Well, because that was supposed to just be a backhaul trying to get him home, and now he got stuck there all weekend.
That's exactly what it was, and he was pissed, and I don't blame him, But so then we go on. So Monday morning, I get in Monday morning, and I'm thinking about this guy over the weekend. I've been in this situation. It's not good. So I'm thinking this guy over the weekend. I get in Monday morning, so I call him up. He was in the door getting unloaded. Okay, all right. Well, holler at me later. And he was still pretty ticked about it. He was wanting to do whatever, and I was like, man, I'm thinking coercion complaint. They were trying to coerce him into the hours of service, breaking the hours of service to make that delivery on Friday morning is exactly what they were trying to push him into doing. And, he just refused. He runs legal, period. And I get a call back from him Monday afternoon, and he's empty, and he was headed to pick up a load, and which screwed up his whole weekend because he didn't get home. But now it's next week. I got to keep on going. So he's headed to pick up a load. And I was talking to him, and I said, "Man, let's make this a coercion complaint. Let's submit this to the NCCDB, and let's put this broker right up there that they were trying to coerce you." And, because at this point, they still would not give him any layover pay, any detention time at the shipper, Nothing. I mean, and they were even mentioning that there may be a fee for him being late, which at the end of all this, they did submit a fee on that too. For him being late for his delivery, it's crap. This stuff, the way this comes down, it's crap. Well, so anyway, so this guy, I told him, give me all the documentation. I want a timeline, everything, for everything, exactly what had happened and how it worked out. So he sent me all that stuff Monday, and by Tuesday, I was working on helping him put together a complaint, something to submit to the NCCDB. And by Tuesday, here's what happened. Here's the really frustrating part, is he decided he didn't know if he wanted to do a complaint because he was worried that the broker would blackball him, would not load him, would submit something to one of these vetting agencies that would blackball him and keep him from going. I was beside myself with it. I mean, how does anything in this industry change if everybody wimps out and just, well, I don't want to make a complaint. They don't want to ruffle the boat, shake the boat, whatever. That's crap. Nothing's going to change if people don't stand up for what's right.
And there's a lot of the common issues we talk about involved in this story. You mentioned detention time. You mentioned layover fees. But you also mentioned coercion. And we kind of moved past that pretty quick. But there's the key moment, is that they were trying to basically tell him, screw the regulations, make the delivery. And, of course, that's if something goes wrong, it's not that broker that's going to be in trouble.
No, it's going to be that driver and or motor carrier, and that's the big issue. There is, they did try to coerce him, and because he didn't coerce easily, because he didn't do what they wanted him to do, it ended up costing him, the whole game. I mean, he laid over for the whole weekend,
and a late fee on top of that,
exactly, and he was in kind of, Mark, I would love to throw out the broker's name on this, but as I know that we try not to go that direction. But, people, read your contracts, know your contracts, and stand up for what's right, because this was not right the way this come down. And if you back down on this, why would these brokers do anything different?
Absolutely. And there was an abbreviation used in there, and I think we need to explain that out. The NCCDB, the National Consumer Complaint Database, which we hate this, but this is the way it is. It's not a place for consumers to file complaints.
Right.
It's a place for truckers to report problems like coercion.
It is. And, when we hear from the FMCSA over some issues, when we take issues, they'll say how many complaints they've got in the database. And routinely, we hear a very low number. And, I tell people, you need to file that complaint. Maybe something will happen, maybe it won't, but it will be documented that there was an issue. And the more documentation you have on any kind of an issue, the better chances you have of remedying that situation.
Well, and I would think that FMCSA would take a vested interest in something like coercion, given the circumstances. And Mark, this unfortunately happens far too often, and it's not probably talked about nearly enough. But a lot of guys and gals, small carriers, will back down because they need these brokers, or it's viewed that they need these brokers because they may haul several loads for these brokers a month, and they don't have 20, 30, 40 brokers that they use. They may only have a few, or that might be 50%, sometimes 100% of their business. They may only use this one broker, and that allows, especially these bigger brokers, to be able to coerce you or give you a hard time in regards to that, because you're viewed as, I need to pay my bills still. I need to make money. I still need to get loaded. All these things. We don't pocket watch you. I'm not going to moonlight here and say that I'm your CPA, that I know your financial situation. I know you still have a truck payment, insurance, bills to cover at home, and so do these brokers. But when you continuously bend over for these brokers, once you do that, there's no stopping them. That same broker will do the same tactics over and over and over to you until it becomes just regular business practice between you two.
And there's something I want to connect here to what you're saying, Aaron, and Tom, what you've said, is when we have a situation where there are no complaints in the National Consumer Complaint Database, a lot of people are like, well, that's what OOIDA is for. And in fact, the association is going to approach FMCSA about these issues, but what happens is they go up there and they say, we've got this problem with brokers and they're doing this and that. They say, we don't have any complaints.
That's exactly what happens, Mark. And it makes it difficult, to make our side of the case when they don't have any complaints. But of course we tell them, these guys are busy. These gals out here on the road, they're busy. They don't have a lot of time to sit around and do this. I mean, they're driving the truck, 10, 11 hours a day. They're probably working on it some, trying to book loads, trying to make arrangements. Filing these complaints doesn't happen near as often as it should.
Yeah, but Tom, I hear these excuses far too often. At the end of the day, you're a business owner, you're an entrepreneur, you're a small business. This is your money. You have to make the time for it.
I agree.
There's no excuses. I'm sorry. No excuses.
I agree 100%. I mean, I understand you have a lot going on, but this is part of it. And if you don't act to it, look at the industry over the last 20 years, how these brokers have become so emboldened and brazen. They just treat carriers as a throwaway commodity. They'll use you up today and throw you out because they know there's 10 more to take your place tomorrow. It's dog eat dog out there. And if you don't stand up for yourself, if you don't do what it takes to make the situation known and deal with it, then you've got nobody to blame but yourself.
Absolutely. And I'll tell you, there's other things here that are kind of didn't happen with your guy, but that can happen in these situations. I know you've talked about when a shipper or receiver delays you like this and you get held over the weekend. What if you already had another load lined up? Now you're screwed on that.
You are. And that broker that you're loading for, they don't care about your next load. And most of these small carriers out there, they absolutely pre-book loads. You've got to, once you drop one off, go get the next one. If you don't pre-book a load, you'll end up with nothing or a real crappy paying load, crappier.
Or deadheading miles away.
Yeah. Yep. So you must pre-book loads, but the brokers, they do not care. And you can be in a situation where the load that you're under is delayed. So then you have to tell the next broker, hey, I got to cancel out on that load. And so then the load you're on, that broker's pissed off that it's delayed. The load you're supposed to go to, that broker's pissed off that you're not there. And, it's a lose-lose-lose for the carrier. So we've got to stand up. Carriers have got to stand up for themselves.
Yeah, absolutely. And folks, real quick, if you are in a situation where you have these problems, any of the ones we've talked about, and any of the many other problems, the National Consumer Complaint Database, it's the website's a mouthful. I just looked it up here, nccdb.fmcsa.dot.gov. We don't expect you to remember that. So here's the deal. We'll go ahead and put it on our website, landlinenow.com, so that you can go ahead and get on there. If you have this situation, we encourage you to do it. The other thing is they do have a phone number, 1-888-DOT-SAFT.
That phone number has a long wait time on it, though. You'll do a much better job at the website, and you can detail your information in writing and supply your documentation.
Absolutely. It's incredibly important, folks. We certainly encourage you to do it and make sure that the FMCSA understands this. And then when OOIDA goes to them, they can say, well, by God, we've got some complaints about this.
Absolutely. Makes a big difference.
Okay. Well, guys, we've run out of time here. Great topic. I thank you for bringing this information. We're certainly sorry about the guy, but thank you for talking with me.
All right, Mark. Thank you.
Thanks, Mark.
I've been talking with Aaron Lynch and Tom Crowley of OOIDA's Compliance Department. We'll be right back. I'm Mark Reddick, and this is Landline Now.
Are you tired of the IRS following you around like a dark cloud? Call 888-557-4020 and get your life back.
At Truck Stop, we've built a better load board for carriers like you. Sign up today and access over 600,000 loads on the most trusted online load board. Learn why the best in the business rely on Truck Stop to make more money and start driving your profit today.
Since you started, what you've loved about trucking is the freedom. Heading out on your favorite route, a good driving song, and thinking about truck insurance. Well, maybe not that last one. That's why we're here. At OOIDA, we have a full range of truck insurance products, expert advice, and great customer service, helping you get the right coverage for your operation. Go to OOIDA.com, because your job is to drive. Our job is to help with everything else.
Landline Now. Welcome back. Earlier this week, a federal appeals court made a decision that will reinstate a requirement that small businesses, including small business truckers, will have to report what's called beneficial ownership information. Here to explain what's happened and what it means to you is Landline Magazine managing editor Jamie Jones. Jamie, how you doing?
I'm going to warn everybody to buckle up because this is a confusing mess.
Yes. Let's start with there's people born every day that don't know what we're talking about here. So what is beneficial ownership information?
Well, it's a requirement that the Corporate Transparency Act, which was signed into law, requires. And it applies to all small businesses with 20 or fewer full-time employees. And basically it's information on the business and the owners and who has a financial stake in them. And yet those are filed with the Treasury Department's Financial Crimes Enforcement Network, which is cleverly called FinCEN, whatever. But they are the ones who you file this report with, and they oversee the reporting requirement.
Why did the government initially put a requirement to file this information in place to start with?
Well, a lot of it's basically to ferret out criminal activity because it's so easy for, a foreign entity or, criminals to form a corporation or an LLC and hide behind that and be anonymous, basically, because you just see the business name. So they're wanting to use this to track down things like, laundering money, drug trafficking. They're even saying terrorists utilize this, anonymous, ability to have these corporations as the name. So that is the whole point of it, is they're wanting to target the criminal element. And when you file that information, the people who have the ability to get that information from FinCEN, it's going to have to be a federal, state, or local government. Even in some cases, it could be a foreign entity that needs to know. But they have to have a legitimate business reason for trying to get that information. So they're trying to act like this is a very secure thing. I know people get real itchy when you're providing your personal information, but they're promoting it as it's not just going to be freely handed out.
Now, we've had a little bit of a back and forth in the courts on this, and this may be the part where it gets a little confusing for people. And boy, am I understating that. Can you walk us through what's happened in the courts so far regarding this?
We've had at least 2 federal lawsuits that have been filed attempting to block this reporting requirement. The National Small Business Association was actually awarded an injunction in March by an Alabama federal district court, but that injunction only applied to the members of the National Small Business Association. So that one was pretty narrow in scope. Then we had another one that was filed in Texas and I love the name of this business, Texas Top Cop Shop is who filed it. And they filed it in the federal district court in Texas. And that was actually awarded an injunction on December 3rd that effectively put the stop to this beneficial ownership information reporting requirement. So everybody kind of really was like, well, the way you get an injunction, the court assumes that you have a pretty good case that you can win eventually. So that's why you get the injunction. Well, that was appealed to the Fifth Circuit, that injunction, who on December 23rd, 20 days later, removed the injunction, effectively reinstating the reporting requirement.
So basically, this is off now. Or this is on, excuse me. See, yeah. I'm confused.
Yes.
But what basically was the reasoning for the Fifth Circuit's action?
Well, the Fifth Circuit actually disagreed with the district court on handing out the injunction, which was a nationwide one. That was why this was a bigger deal than the Alabama case. So that nationwide injunction. So they disagreed with that. So they kicked that part back to the district court and told them to go ahead and rule on the constitutionality claim that the Texas Top Cop Shop, I love that, is making against this Corporate Transparency Act.
Okay. So we had a couple of deadlines on this previously at the beginning of all this, and it depended in part on when your business was incorporated. So I'm wondering if you can walk us through what the deadlines are now.
Yeah. So it's messy, as you would assume. So originally, there were two different deadlines. Businesses created after January 1st, 2024 had 90 days to file this. So, and then businesses that were created before January 1st, 2024 had until the end of this year to get that filing done. So when that injunction, that nationwide injunction went in place, all those, it was messed up because then we had 20 days where the whole thing was in limbo, basically. So now FinCEN has extended the deadline to January 13th of 2025, and that also applies to the businesses that may have been formed after September 4th because their 90-day requirement was falling in that range where we had the injunction. So, the short end is right now, if you haven't filed it, you better be filing it because it's going to get really expensive if you don't.
How do people go about filing?
Well, it's actually really simple, and we probably need to throw a scam warning on asterisk on this too, because it takes 15-30 minutes through the FinCEN website, and we have a story with this information on our website, landline.media, so you can go there. You do not need to pay a service to do this. And there are some out there that we've had reports of $1,500, $2,000 just to file this. It's really not that big of a deal. As far as the actual act of filing it, it's not a complicated process. But if you do have questions, you should call OOIDA. We've got people who have been dealing with this for a long time this year. Really kind of helping point out what you do need to do, what you don't, how to do it. It's not necessarily a service that OOIDA provides to physically do it for you, but we will be able to walk you through that process.
And again, folks, if you do need to call OOIDA about this, the phone number is 816-229-5791. Again, that's 816-229-5791. You mentioned kind of the scam there, and we've been seeing this with other things as well, but I don't know if we've had particular reports, but this really is something people need to be on the watch for.
Oh, 100%. I mean, and they'll come in looking like official documents. I mean, FMCSA has a whole page dedicated to scams, and considering that FinCEN, that's what they actually are doing is trying to ferret out the criminal element. Obviously, there's going to be scams circling that. So I think it's important to just know that you are on the actual official website when you file this information. I would not go through a third-party provider because in this day and age with identity theft, I know a lot of people are very concerned about what personal or even business information. I mean, we have motor carriers who have their identity stolen too. We have this happen all the time. So you really want to be careful and not get hoodwinked into working with one of these scam operations. So again, like I said, the link is on our website, landline.media. If you do have questions, please get a hold of us or even call the Treasury Department. I mean, they should be able to walk you through that as well. But it's not a super cumbersome process. It's just the fact that they want your personal information.
Just one last question. We've got about 30 to 40 seconds left. The court battle isn't over yet, is it? This is potentially going to continue.
Oh, it will continue because the big question hanging out there in the Texas District Court is whether this law, the Corporate Transparency Act, is constitutionally valid or not. And, in talking with attorneys, that is never a fast process. That is one where the courts will just grind through. Eventually, we'll get an answer, but it could be overturned ultimately, or it could just be signed off on and blessed, and this is going to be something that everybody has to do from now on.
Okay. Jamie, thank you very much.
Hey, you're welcome.
I've been talking with Landline Magazine Managing Editor Jamie Jones. And folks, again, the website where you can do this for yourself, which is how you should do it, is FinCEN. That's FINCEN.gov/BOI. That's our program for today. Thank you for joining us. I'm Mark Reddick, and this is Landline Now.
Thanks for listening. Be sure to like and subscribe. If you want more content, go to landline.media to get updated news, information, and archived editions of our show. Once again, that's landline.media.
I'm a dad.
A son.
A husband.
Wife.
I'm a writer.
Photographer.
I farm.
I'm a veteran.
I love old cars. Fishing.
My kids.
Chrome. And I am
a professional truck driver.
And together we are OOIDA.
OOIDA was founded by truckers to stand up and speak on behalf of truckers. We've done that by combining the individual voices of our members into a single, powerful voice. Protecting your interests, defending your rights.
Join us! Make your voice heard. Join OOIDA, the Owner-Operator Independent Drivers Association. Call 1-800-444-5791 or visit OOIDA.com.